kami telah memohon untuk menjalankan pendengaran habeas corpus bagi keenam yang telah ditangkap dan ditahan, dan pihak tim peguam bagi semua tahanan-tahanan bersedia untuk menjalankan pendengaran. Namun begitu, pihak responden iaitu kerajaan dan ketua polis negara telah memohon supaya supaya kes ini ditangguhkan untuk 2 minggu untuk memfailkan affidavit lanjutan kepada affidavit kami. Kami telah membantah dengan sekeras-kerasnya, dan kami telah menyatakan bahawa pada hari ini dah masuk 20-21 hari dan ada tahanan-tahanan yang telah masuk hospital, dan juga kita bimbang terhadap kesihatan, dan juga kes habeas corpus sepatutnya dijalankan dengan secepat mungkin. Namun begitu, Hakim Mahkamah Tinggi telah membuat keputusan untuk membenarkan permohonan responden government untuk menangguhkan prosiding sampai 5 Ogos 2011 bagi pendengaran. Mereka akan memfailkan affidavit jawapan. Kami juga menyatakan bahawa ini tidak seharusnya berlaku kerana alasan yang satu alasan saja, only one reason, kerana enam ini ditahan adalah kerana bersih pada 9 Julai 2011. So sebenarnya kami menyatakan hari ini memohon jasa baik mahkamah untuk menimbangkan alasan ini saja, dan boleh menimbangkan atas affidavit, tak perlu affidavit lain. Kerana 9 Julai dah habis. Hari ini 22 Julai. Jika alasan itu sahaja yang menahan ke-6 tahanan ni, tak perlu apa-apa affidavit lain. Jadi itu alasan yang kami hujahkan. Tapi mahkamah kata memberikan peluang kepada responden untuk membuat affidavit lanjutan untuk menjelaskan perkara ini, dan kami telah berhujah I think semasa 2 jam untuk membantah penangguhan ini, tetapi Hakim Mahkamah telah bersetuju untuk menangguhkan. Jadi itu status kes pada masa ini. Kami telah memberitahu Hakim juga pada 5 Ogos, on the 5th of August, it will be more than 1 month that they are being detained. And this is very, very unfair. And the most important thing is the liberty of the subject under the Constitution. So we will definitely be ready to proceed on the 5th of August. We are in fact ready to proceed today. And this is the best that we could do for the Sikhs. We will continue to visit them, and I think the people needs to continue to fight for their release outside, and continue to keep talking about it, continue to keep pressuring the government about this issue. Okay? We have to look at the affidavits, but most likely we will not, because they have to justify the detention. And we have already said clearly what our argument is. We are very open from the start, because this detention is unreasonable, this detention is ridiculous. From the start, we have said what our case is. There's nothing to hide. And there's nothing else they can say, actually, regarding the allegation. Because the allegation is only 9th of July. But 9th of July has passed, and you have not arrested any of the Bersih leaders. So what are you talking about? This detention is clearly mala fide. So our case is very open, and everybody knows that. We have already put out our case today, and it's for the people to judge. It's for the government to see whether this argument is reasonable or not. And I think this argument is very reasonable.
Do you want to say something on the academic?
On what basis?
On what basis they need to file another affidavit?
We had filed further affidavits. We had filed, for example, one affidavit by Subramaniam Pillai from Bersih to say that the PSM 6 were not part of Bersih. We have filed I think about 8 other affidavits from those who were detained with the 6, the 24 of them, to say that they were forced to confess, they were forced to admit, they were asking questions to implicate the 6, to show mala fide on the part of the police. And we have also filed the affidavits from the detainees themselves, talking about the interrogation. So all these affidavits, they want to reply. But we said that if we still want to proceed, we can drop all these affidavits. Because the only ground really is the Bersih ground that they have gone on. They cannot come up with any other ground now. They cannot talk about anything else. So all this talk about socialism, communism, weapons and all this is wholly irrelevant. Because on paper the government has said it's only Bersih.
So why did the judge grant a postponement even though you were prepared to drop all the additional affidavits?
I don't know. The judge has the discretion. So the judge exercised that discretion. Of course, we every second, as Imtiaz from Bar Council said, every second of detention that is wrongful is a second too long. And we feel the same as well. But we tried our best in the circumstances. We hoped for a better result. But now the judge has fixed the 5th of August. If we want to respect the court process, since we've come to court for help, we must continue to respect the court process. If we are not happy with the decision at the end, then we have to appeal it. But at the moment, what the people can do outside court is as important as what happens inside court. Normally, in this type of cases, the minister's order will be issued just before the hearing, like in Chomel's case, and in other ISA cases. So we said that it's very important that the government maintains a status quo, if any. Of course, we want them to be released immediately, but it shouldn't be turned into a government restriction order.
Bebas! Bebas! Bebas!